Number 67, John W. Terry et al., Petitioners versus Ohio.
This is not just a Supreme Court case. This is the moment American policing changed forever. Not because of a robbery, not because of violence, but because the Supreme Court finally answered a question it had avoided for decades. A question that still follows you today. A question that decides whether a police officer can stop you, detain you, and touch your body even when you have done nothing illegal. It is October 31st, 1963, downtown Cleveland, 2:30 in the afternoon. Detective Martin McFadden stands in a storefront doorway, plainclothes, unmarked, watching. Two men walk back and forth along the same block. They pause at the same store window. They quietly confer. Later, a third man appears. He speaks briefly. Then he leaves. No crime has been reported, no alarm, no victim. McFadden has no evidence that a crime has been committed, but something about them bothers him, and that feeling will reshape American law.
In the record,
What was your answer?
he said, well, to tell you the truth, I didn't like them.
Didn't like them.
Yes.
Dislike is not evidence. McFadden approaches the men. He identifies himself as a police officer. He asks their names. They mumble a response. That is enough. McFadden grabs John Terry, spins him around, and runs his hands along his coat. He feels a gun. Another man has one too. They are arrested. But here is the critical fact, the one that almost ended the case. Even the state of Ohio admitted this. McFadden did not have probable cause when he first touched them.
So he didn't have probable cause to arrest when he approached,
I would agree with this.
and he didn't get probable cause till he put his hand on the butt of the gun.
He didn't get probable cause to arrest
Him until he put his hand on the butt of the gun in his inside coat pocket.
Before Terry versus Ohio, that should have been the end. Probable cause was the constitutional line. It required real facts, not guesses, not instincts, not feelings. If an officer sees someone smash a window and climb inside, that is probable cause. If a witness points and says, that is the person, that is probable cause. Ohio admitted McFadden did not have it. If he didn't have probable cause, what gave him the right to put his hands on him? That question split the court and forced a new one. Is there constitutional space between freedom and arrest? Can police briefly detain a person and physically search their body without probable cause? The Supreme Court answered yes. It created a new standard. Reasonable suspicion. Less than proof, but more than a guess. A person may be stopped, detained, not arrested, but not free. A legal middle ground the Constitution had never recognized before. This is why today, a police officer does not need to see a crime. They only need to explain themselves later. If an officer reasonably believes the person may be armed and presently dangerous, the officer may frisk them. Not for evidence, not for contraband, weapons only. This standard does not require certainty. It requires explanation. An officer must later say why the behavior looked suspicious, based on training and experience, based on observation. After Terry, that is enough. Before Terry versus Ohio, police were already stopping and patting people down in practice. Courts dealt with those encounters later, quietly, in suppression hearings. Some evidence was allowed, some evidence was excluded. There was no national rule. Terry created one, and in doing so, it permanently lowered the constitutional threshold from probable cause to reasonable suspicion. Chief Justice Earl Warren wrote the opinion. He did not pretend this was harmless. He admitted stop and frisk is a serious intrusion on personal liberty, not a minor inconvenience, a real invasion of the body. But Warren drew a line. He said, the Constitution does not require police officers to gamble with their lives. He reminded the court that the Fourth Amendment protects people, not places, and that protection follows you onto the street. Still, he concluded that when an officer can point to specific and articulable facts suggesting a person may be armed and dangerous, a limited frisk is constitutional. Not to punish, not to gather evidence, but to survive the encounter. And even the justices knew this rule was dangerous. Justice William O. Douglas dissented. He warned that suspicion-based searches give police more power than judges, that this was exactly what the Fourth Amendment was designed to prevent. Justice John Marshall Harlan concurred. He agreed with the outcome, but only with limits. A frisk is lawful only after a lawful stop, and even then, only for weapons, not evidence, not convenience, not fishing. The justices understood what they had created, a new kind of encounter, a moment where a person is not arrested, but not free.
He received probable cause for arrest when he turned Terry around and ran his hands over the outside of his clothing and feeling a gun in the upper left breast pocket and indicating emphatically at that time that what I felt was a gun, a weapon.
Subscribe if you'd like to see more. Thanks for watching.